Good night, Belizeans at home and abroad. This is the Belizean Affairs Show number 459. 459. My name is Leonard Brackett. I'll be your host and chairman for tonight. And I don't see any of my other colleagues in the background yet or other panelists. So I'll just proceed with the program. We normally will do a short prayer, after which we do a scripture reading, and then we deal with our program proper. Uh, I would just like to ask that you allow me an opportunity to launch this other part of the program so other listeners can gain access to what we have to offer tonight. And I just need to put this live just for a second. Okay. And then let me see. I need one more. What else do I need to do? Just need to edit just for a short minute more. I want to these interfere. Sure. 459. Okay. One more minute. Okay. So that's good enough. I'll save that and then I can proceed with the rest of the program. Uh, like I said, we normally start with a prayer and then a short reading. So I'll just bow my head for right now and say a short prayer. Divine loving Father, once again we come before thy presence, asking that thou would accept our humble expression of gratitude and thankfulness to you for having given us the privilege of life, first and foremost, and for granting us the privilege to still be alive among our family members, friends, and loved ones. Please bless our country of Belize, its people and leadership. Please bless this country of the United States, its people and leadership. Please bless the rest of humanity, those who are in wars and zones where people are losing their lives and liberty as well as their limbs. Pray that thou mayest have mercy upon them. Those who are suffering from hurricanes and earthquakes and volcano eruptions and uh, other natural disasters as well as man-made disasters. We pray that thou mayest bless our family members, friends, and loved ones wherever they are, as if they will be all mentioned by name and number. Whatever we have to say tonight, Lord, may it be to thy honor and glory as well as to the glory and benefit of our country of Belize. Bless his mercies in Jesus' name. Amen. I'll do a short reading from the book of Songs of Solomon, and I'll just read let me see here, chapter 6, and I'll start at verse 1. It says, "Whither is thy beloved gone? O, thou fairest among women. Whither is thy beloved? Turn aside, that we may seek him with thee. My beloved is gone down into his garden, to the head of to the bed of spices, to feed in the garden and to gather lilies." And that is our reading for tonight. Thank you very much for allowing us to indulge in that part of our programming. Uh, for tonight, being Friday and being the nights when we deal with legal matters as well as constitutional matters and lawful issues, I would like to take up a particular issue. And let me just try and pull this up quickly here. Let's see. Okay. Okay. Uh, my subject for tonight is an issue that relates to a recent High Court ruling. When I say High Court, I'm referring to the High Court of Belize. Um, I think it was on the 7th of this month that ruling was made, or was it made on the 6th and published? The information was, well, July 7th is the date of the article. So let me stay with that and not get into the weeds, too deep down. So I'll start by saying that the High Court rejects bulk of businessman's claims against the police. It is quite widely known that in Belize we have a problem with the conduct of the police officers who are supposed to be peace officers. In other words, they're supposed to keep the peace and help to keep the peace rather than acting as scofflaws, breaking the laws, committing crimes against unarmed civilians under the color of law. In other words, a police officer is empowered with some authority from the state, and they're not supposed to use the powers of the state to victimize civilians, per se. Nor are they supposed to act as judge, jury, and executioner in the process of doing their job, because they are not judges, they are not executioners, they are peace officers. They're supposed to maintain the peace, and they're supposed to operate under certain procedures, protocols, and lawful order. They're supposed to abide by the Constitution and carry out their responsibility in a lawful and legal way. Nevertheless, in many instances, we see where police officers overreach and abuse the authority vested in them and carry out what you call judge, jury, and executioner actions and behaviors uncalled for in some instances. There have been occasions where sometimes a police officer may need to resort to heavy handed behavior, and in some other instances, they need to resort to even violent behavior. But that violent behavior must not fall into the category of abuse of power or abuse of state power, which is what they're vested with. Or for them to, on behalf of their friends or colleagues, or on behalf of their family members, or on behalf of the ministers of state, ministers of the government, or any other state functionary, that they should go out and behave honorously. Why? Because they're authorized to exercise some level of state powers to carry out their duties. In other words, they're not above the law. Uh, I'll read the article, and before starting to read it, I'll just say right off the bat, it's kind of a lengthy article. I will attempt to read through the article and then come back and make some comments on the article, rather than read one portion of the article and then make a comment, and then read another portion and make a comment, as would be normally our way of doing it. I've taken the opportunity tonight to do it in a little different format. That is that I'm going to attempt, hopefully without any extenuating or extensive commentary, to just do the reading, and like I said, hopefully come back, have enough time left in the program to make some general comments. I don't see my colleagues yet, so I'll just proceed. The article went on to say a high court judge has thrown out most of a businessman's lawsuit, which accused police of unlawful detention, assault, and years of extortion, ruling that the bulk of his claim, that is, the court ruled that the bulk of the gentleman's claim were filed too late, and that others were pleaded too vaguely to allow it to proceed. I'll continue to do the reading. I'm tempted right now to make some comments in regards to the specifics of that particular paragraph, but I've already offered not to I've already offered to try and do the reading and resist the temptation to make the comments right there and then. So I'll proceed further. It goes on to say, Justice Raiji Gudet, I can't make this pronunciation, Gonet Tileki, I hope I'm not botching up the gentleman's, the judge's name. The judges delivered the decision late last month in a claim brought by Omar Avelar against the Commissioner of Police in Belize and the Attorney General of Belize. Avelar's claim, which is the name of the gentleman, Avelar, his claim, filed in February 9th of 2026, centered on his arrest on May 5th of 2024, when he was detained and charged with failing to provide a specimen. We all know that in police work nowadays, when the police stop you for whatever reason, especially if you're driving, or they smell alcohol on you, or they smell some kind of other, you know, intoxicating drugs or whatever, or if they don't even smell nothing on you and they just want to check you out, or if they just want to plant something on you or accuse you of something, they follow the same procedure. That is that whether it's an entrapment or whether it's a legal, lawful action on their part without any unnecessary malice, aforethought, and whether or not they're doing their job, just the way it's supposed to be done, they're allowed to require of you a specimen, either of your saliva, or they take you and have you do a urine test, or some kind of other test to confirm or affirm that you have or have not been dealing with any kind of drugs. Okay? And that is only one item or condition under which they can, demand specimens of your person or your persona. Okay, so the gentleman, he was detained and charged with failing to provide a specimen. possessing a firearm while under the influence, and possessing a pistol loaded with 18 rounds of ammunition. He, the gentleman, alleged he was unlawfully detained and charged, and that he suffered physical injuries, including bruising and burst lip, and being choked and, and stomped on his chest during the encounter, and that his wallet and iPhone were missing. I go on to read. I'll come back to try and. Oh, I need to give attribution to the place of origin of this particular item that I'm reading, right? Let me just make sure I do that. Um, it's a Great Belize. Let me see. It's the Great Belize Media House. I think that comes under Channel 5 of Belize, Channel 5 organization, greatbelize.com. Okay, so that's where the article originated from, and I needed to make sure I gave the attribution. I did say it was an article that I was reading from somewhere else, but I did not give the attribution as to where it was that the article came from. And those people do their hard work to produce these materials, so therefore, at the least, from a professional perspective, uh, I need to make that citation. Okay, let me proceed further. Okay, so Mr. Avelar alleged a broader petition of police harassment and extortion during dating back to 2021. So, okay, let me leave that. He claims uh, two named officers, apparently he had produced the names of those officers, extorted from him Belize dollars 1,200 from him by checks in June 2021, and then further unspecified sums of Belize dollars 800, 650, and $1,500 were extorted from him and family members on, or on unstated dates. He never provided dates for those additional extra extortions. And that was done by unnamed officers. That is, that he never provided the names of the officers who did the extortion or those funds. He just provided, in a particular instance, the name of two officers, which were associated with the first extortion, but not with the follow-up extortions. He sought special damages of Belize $193,250, along with general damages for emotional distress and reduced quality of life. That is, that he was beaten up so bad that he suffered all those effects, and his quality of life had diminished. As for his allegations, the Commissioner of Police and Attorney General applied to strike out the claim entirely, arguing that it was filed outside the 1 year limitations which means that even though the crime may have been committed, they were trying to get exculpated from answering to the crime because it was beyond time of the limitation. The 1 year limitation period that applies to actions against public officers, and that the extortions allegations were too vague to meet the court's pleading. There's a process or a procedure by which those allegations have to be processed. And so the Attorney General and the Commissioner of Police legal representation requested that the judge throw out the case basically because it was filed too late, which amounts to technicalities. Um, let me just continue the reading. I'll come back. I have an urge to tackle those items, and dispense with them and or elucidate the reason why I feel like there was some hanky panky going on here in regards to this particular ruling. But let me just proceed. Let me see how much more I got to read. Oh, it's quite a bit. Oh man, yeah. Well, I made the promise, so I might as well stick to it. I'll just okay. I'm trying to get back to where I was before. Okay, okay. So they had applied to the Attorney General and the Commissioner of Police applied to have the matter struck out under technicalities because of the 1 year period that had already elapsed. Not that the crime hadn't been committed, but for technicality reasons, he should not be allowed to carry the case forward. Uh, that applies to actions against public officers, and the extortion allegations were too vague to meet the court's pleading requirements. The justice split the claim into two categories. One, the first, covering the May 2024 detention charges, alleges assaults, alleged assaults, and loss of property. He found was clear time barred. That is that what I mean when I say clear time barred is because the gentleman may not have known, and for not knowing and did not probably have proper counseling or proper legal advice or input, he did not file his case within the time period that is required if you're going to sue the government or any of his officials. You have a 1 year period to do that. And he apparently, according to this particular statement, had not complied within that 1 year. Therefore, they were trying to get his case struck out and barred from being able to continue. Under Section 27 of Belize Limitation Act claims against the public officers acting in execution of their duties must be brought within 1 year, and the judge held that uh, that the cause of action uh, crystallized on the date of. Let me double check something here. Yeah, on the date of the incident, rather than continuous uh, rather than continuing uh, uh, afterwards, rejecting Avila's, which is the name of the gentleman, argument that it should be treated as an ongoing wrong. That is, that the gentleman had claimed that not only was he beaten up on that particular date in question and mistreated, and he lost his phone and other items, he suffered thereafter, and he also, uh, over a period of time, after that date, he was extorted on the various occasions for which he provided the sums and the time, but he did not provide the name of the individuals. Um, and that was on the first group. On the second uh, category that the judge came up with, he said that the extortion allegations received mixed treatment. That is, that the judge found the claim concerning the unnamed officers. The gentleman apparently could not come up with the names, and undated payments. Uh, he found those to be impermissible, vague under Civil Procedures Rule number 8.7, subsection 1, which requires a claimant to state state the facts relied upon and struck them out. The judge went on to strike them out on that basis. That is, that the gentleman did not comply with section rule number 8, Civil Procedures Rule number 8.7 at subsection 1. Now, these are legal technicalities that a lawyer should have been able to help him with, but for whatever reason, apparently he could not get legal advice or legal help until a certain period of time had passed, and by the time he filed the stuff, you know, he had not met compliance with these particular codes, which requires a claimant to state the facts relied upon, and the judge went on to struck them out on that basis. So, for all intents and purposes, the gentleman case got reduced substantially or substantively. However, the allegation naming two specific officers on a specific date and amongst survived both challenges. That is, that the officer, the two names that the gentleman was able to come up with, as well as the amount and the date, the judge found that those parts of the case should remain. In other words, the case was weakened, but not totally decimated or totally taken off the calendar, or he did not rule 100% against the gentleman. He allowed him to be able to proceed with the case with a reduced case. Therefore, he would not be able to provide all the evidence that he might have had or wanted to provide, because some of it, or some of the judge, what the judge did as a part of the case management process, he disallowed certain things that the gentleman was probably hoping to, maybe his lie. It doesn't say anything here about the man lie. It just speaks about the man, right? So we could presume that maybe the man didn't have any lawyer, or if he did have a lawyer, that the lawyer did not deal with those matters and or try to put up any objection to the judge's case management process in terms of disallowing the gentleman to submit his evidence, and by cutting the case down to a small portion of it, had weakened the case substantively. But I'm still doing what I said I wouldn't want to do, which is to make the comments. But I'm just making those comments, uh, despite having said I would try to wait until after the complete reading. No, just for elucidation purpose. But I'm breaking my one promise to try and do the reading first. Let me move on then and do some more of the reading. Um, okay, so let me see. I don't know. It says the judge found sufficiently. The judge found it sufficiently pleaded and reasoned that extortion, unlike lawful policing actions, is not an act done in the execution of any statute or public duty, and therefore falls outside the limitation protection at all. He cited a Privy Council decision, which is the highest authority in our legal systems prior to us going to the Caribbean Court of Justice as a final jurisdiction. We used to have the Privy Council. So this judge used a former Privy Council decision, which held that protections for public authorities must be construed restrictively and apply only where the obligation in question is one owed to the public generally, not to conduct that could equally arise between any two private persons or parties. I'm almost at the end of the reading, so let me just move on and try and finish it up. The defendants were ordered to file their defense to the surviving allegation or the rest of the allegation that the judge allowed for them to pursue by July 9th of this year, with Mr. Avelar permitted to reply by July 24th of this year. The matter is set for further case management on July 29th, and Mr. Avelar was ordered to bear the cost of the strikeout hearing to be argued upon or to be agreed upon or assessed. Let me deal with that last part there quickly. If the judge had already gone ahead and, as part of the case management for that particular case, had decided that the gentleman could not submit all the evidence that he wanted to submit for his larger case that he presented, if the judge, through the case management process, had already reduced the gentleman's ability to effectively prove his case then, and had allowed him only to continue forward for further case management purposes on the dates that were listed here, for example, on the 9th, by July 9th, and that they were supposed okay, they were supposed to submit by July 9th, so the small part of the case that he allowed them to. And by the 24th, they're supposed to have a respondent from the other party, so that the judge could go ahead on the 29th of this month to do an additional case management. It meant then that the case had not been fully disposed of. They just went through some mechanics of the case management process. So then, why is the judge? We haven't gotten to the 29th of July yet, and he would not have done his case management yet. Why is he then ordering that the gentleman should pay for the case management uh, let me say it here exactly in his words. Avelar, which is the gentleman we're talking about, was ordered to bear the cost of the strikeout hearing. The strikeout hearing is part of the same case management process. The fact that the judge limits him to present his stuff, the judge is doing it on behalf of the other party. And only if the other party had won the case, the substantive case, which was originally submitted, despite the fact that the judge told the man that he can't present certain evidence, it didn't mean that the gentleman had lost his case yet. And until the judge rules on the case, the substantive case, and decides who is the winner or loser of that particular case, then the judge would not be in a position, or should not be in a position, to tell the gentleman that he have to come up with money and find money to pay the other people that he's suing, which is the government, okay? To pay for the cost of what the government may yet lose the case on. After the case is ruled upon substantively and finally, then the award is to be made as in regards to who won or lost the case. If the gentleman goes on to win his case, then he should not be penalized. The fact that the judge is throwing out some of the gentleman's evidence on the basis of technicality doesn't mean that the crime was not committed, and he's allowing a part of the case to go forward for final judgment. He should wait until he decides in the final judgment, after the case is fully heard, and he decides, okay, well, the government has won, therefore the gentleman should pay because he's the one that took out the suit against the government. But they haven't gotten to that stage yet. But he wants the gentleman to go find money to pay the government for the government having committed a crime under the color of law against the gentleman. Now, mind you, if you notice, as of right now, we're not talking about the people who did the physical assault on this gentleman, who broke the law under the color of, who broke the law, and who did so under the color of law for being police officers themselves. Okay? So they are not nowhere answering to this pleading that the gentleman alleged. Why? Because the way the system is set up is that if you want to sue the government, you can't sue the person that committed the crime. You got to sue the Attorney General on behalf of the government, or officers who work on behalf of the government. So this judge is going to make some temporary stipulations to the court management process instead of waiting until he hears the case, which he is yet to set a date for hearing the case itself, which is sometime in the future. Okay? He's going to go ahead right now and order the gentleman to pay the cost of the case management and the faulty decisions that he made. He should not be making any judgment in that regards. Well, not, I won't say any judgment. He's entitled to make a judgment. That's his rights and responsibility as a judge. But he should not be colluding with the government, if I'm going to say it in that kind of way, because he has not ruled on the case, on the merits of the case. After he hears the merits of the case, he may then end up realizing that, okay, well, the gentleman supposed to prevail based on the evidence he is allowed to provide, even as reduced as the evidence may turn out to be then. If he doesn't probably turn around and say, well, the gentleman may not be able to produce or submit or accept into evidence other things that the gentleman tried to submit later on. So yet the gentleman could yet lose his case because of technicalities again. Or he, the judge, may find the gentleman to be aggrieved and to be within his rights, to have the court rule on his behalf, to justify his constitutional rights and the violation of his constitutional rights. So then what's going to happen? He won't turn around and tell the gentleman, if he finds that the gentleman's constitutional rights were violated by the government, that yes, he was right to sue and he should prevail. And maybe he should get whatever the judge at that time decide should be good enough to make the gentleman whole. Yet after having put the gentleman in the hole to pay the government for the cost of the preliminary hearings that he did, whoever wins the case is exculpated from having to pay any damages. He can't preemptively rule that this gentleman should pay damages when he hasn't heard the case in total. I think that's a travesty, especially now that we have in our jurisprudence a bunch of scamps that are acting in such an onerous way that even the appellate court, which is above the Supreme Court, have to lecture the people who are running the Supreme Court for their shortcoming and their violation of judicial ethics, because they have been found to be contravening the very professional ethics that they're supposed to abide by. And therefore the appellate court had to lecture them about their misconduct and misbehavior. We have judges sitting on our bench, lying on the bench, and conniving and contravening their judicial oath to be impartial and to rule according to law. I could call names if I need to. But we have done programs on this particular issue quite a few times on this platform. We have 48 programs, among which we have dealt with these particular issues and with these particular judgment that I'm speaking about tonight. And most of those things were aired out then. Names were called. The Constitution was cited. The case laws were cited. And the misbehavior was cited, as well as the rulings from the court, from the higher court, were cited. So it's not like I'm talking above my head or saying something that is not right or proper or true. I'm just making reference to what we have dealt with in the past. And we have found out that we have honest people sitting on our benches. They're not abiding by the rules and regulations. They're not abiding by the Constitution. They're not ruling according to the established stare decisis or settled law. They're conniving to exculpate the government from having to make amends for transgressing the Constitution. And the Constitution says in black and white, in plain language, that the government should not do certain things. And other judges had ruled that the government was wrong and that they're supposed to pay some of these people that they aggrieved or that they did wrong to. And up to today date that we're sitting here having this further discussion, the government has not followed through and done what was ordered by the court. So as to say, the government choose to be like scofflaws and choose to ignore the court and to leave the court with the impression that unless the court comes and act in the capacity of the government and do what needs to be done, they, the present government, will not do it. To hell with the court. So we have people in the government and in the judiciary colluding to undermine the fundamental rights of our civilians who don't have money to sue the government and who cannot get the court to follow the constitutional requirements. That's a travesty. That's not the way it's supposed to be or is intended to be. But yet these onerous scofflaw people, some of them cloaked with the robe of the judiciary, and others cloaked with the authority and the power of the governance, legal prerogatives and the authority behind them, collude against the very civilians that they're sworn to uphold and protect, whose rights they're supposed to uphold. I want to go back and make a quick commentary. I said I wasn't going to make the commentary initially when I first read it through. I have enough time, so I can go back now and make specific commentary on specific portions of this article that I was reading that came from the Great Belize Media House. Okay. So the High Court judge, whose name I try to Justice Rajiv Gunetelli, no, Guneteleki. I can't pronounce it. I'm having a hard time being able to make that pronunciation. And in attempting to do so, I'm just probably making a fool of myself and batching up the judge's name. So let me just desist from calling out the last name. I'll just say Justice Rajiv. I'll just use one name, you know. But Judge Rajiv, throughout the biggest part of the man's case, Mr. Avelars, this is a gentleman, throughout most of the gentleman's case, and proceeded to order that the gentleman pay for part of the case management that he, the judge, had resolved that the gentleman has the right to proceed with the case, and under the condition that it was not a bogus case that the gentleman presented, other than the fact that he presented some of the material too late, and some of the material that he presented was faulty by our legal standards. Of course, you know, we have to accept those premises as well. But you cannot, as the government of the country, the Attorney General, use public funds to play high-class legal maneuvers with a civilian who doesn't have the treasury, the public treasury at their disposal to be able to hire all kind of high-class lawyers. The government should not be able to use powers of state, the treasury of the state, to exculpate treacherous behavior, illegal and unlawful behavior of officers of the state. That's not what it's supposed to be about. But that's how these people are operating. The judge is cutting down the gentleman's case against the government, and then the government is using the treasury and the legal system to exculpate onerous behaviors by the police officers. No wonder we have the system that we have. We have the system we have because of the onerous behavior and the way these people scratch each other's back and protect each other. What that kind of behavior leads to is people taking the law into their hands because they can't beat the government with the government coffers and with all the power and authority behind the Attorney General and the court falling in line lockstep to exculpate treacherous behavior on behalf of public officials. They should be brought to account. And if the people who have the authority and the power to see to it that these stormtroopers stop victimizing people and then hiding behind the powers of the state, then people have to do what they have to do, which is why I don't have a tear to drop for them when you have other people firing bullets at them. It ought not to be like that. But that's what people have to resort to in order to, settle their own internal struggles. When you stop a people from having justice rendered to them, you leave them without any justice. And when a people doesn't have justice, they resort to unjustified measures and means to, self-vindicate. Nobody's going to sit around and have the government oppress them or sit on them or abuse them, just because the government is authorized with the powers of the whole society behind them. There are rules and regulations, there's law and constitutional requirements that precludes a government from behaving in that kind of manner. I'll read on, and I have a couple other commentary that I'll make before the show is expired. As regards to the timing, yes, the matter may have been still dated. It wasn't filed timely according to the procedures and the protocols and the process of the court system. But that of itself doesn't make the crime not having been committed. If the crime was committed, the legal system should provide for the person on whose that crime was committed to be able to have redress to that crime. You just cannot tell that person to get out the court, get away from the judge, and go about their business because the court cannot entertain the fact that they are coming in late with their processes. You cannot and should not be throwing a person's case or eviscerating a person's case when that person is using that means of filing that case to come and get redress from the court. Not everybody understands the rules and regulations. And even some of those who understand the rules and regulations, there have been judges who allow for vindication when your rights are violated. They do not entertain these scofflaw behaviors and these technicalities and suppress people and oppress people's rights. The exercise of the Constitution and the constitutional rights which the Constitution enshrines, and some of those rights which the Constitution does not give you, but that you were born with, your inalienable rights, for example, your natural rights, for example, all the Constitution does is codify those. It doesn't grant them to you because it has no power to grant those you were born with. All the Constitution does is to enshrine those enumerated rights so that people can recognize them as having been spoken to as your rights. But there are many other rights that are not spoken to in all constitution and or all legal processes or documentations. I don't understand how. Well, I shouldn't say I don't understand. I do understand, but I understand why is it and how is it that the government goes about behaving in that type of way. Okay, that is to say, who's going to make them do otherwise than what they choose and want to do? Because, like I cited earlier, there have been cases where even the court itself, the High Court, and the appellate courts, and the regional final court of jurisdiction in the Caribbean have pointed out to the government and to the legal system that they had committed a breach and requested that they correct those breach. And the lower court does not follow through, and the government plays the fool and goes along. Now, when the gentleman was arrested, he refused to give uh, um, a specimen, right? Provide a bodily specimen. The fact that he was found with a gun at the time doesn't mean that the police can use that fact to twist it and overinflate the charges against him. If the gun was illegal, that's a different matter. But if the gentleman had a legally acquired gun, a gun that was legal and that was his own, he was not a previous criminal, so therefore he would not have been barred from being able to have possession of his weapon. Yeah, I'm getting some information here. Nevertheless, I'm saying that a lot of police officers have a tendency to overcharge in some of these action or activities. Okay, they overcharge, and sometimes the overcharging is reduced by the DPP, the Director of Public Prosecution, and or sometimes the Director of Public Prosecution refused to carry the case forward, and that person then is classified as a nolle prosecutor. That is, that they will not prosecute that person, either for insufficient evidence and or for lack of evidence. Sometimes the evidence is provided or acquired during the investigative process, and sometimes those very evidence are disappeared out of the files before the court hearing. Now, the person that is being charged or that is being accused have no access to the files of the police department. So how the devils those files can be disappeared out of the police safety and security, the custody? it means that somebody inside there is pulling a fast one on the system. And that's been happening often. As a matter of fact, we have the situation just recently where the police commissioner himself was put on interdiction for 45 days because he produced a report to the Prime Minister, which, by the way, was illegal, unlawful, and unethical, because no way should the Prime Minister had possession and or access to any police file that should have gone to the DPP for prosecution purposes. It is not the purview, the prerogative, and or the rights of the Prime Minister to have custody or access to any of those legal files, because by breaking that chain of custody, they create or invalidate a potential proper legal prosecution and outcome. Because any good lawyer could have saved their client under those circumstances and make it worse. Even though the police commissioner was put on interdiction by the Prime Minister, because the Prime Minister claimed that the commissioner did not provide him a proper report. That's what he claimed to the public. The public did not get to see that report to know whether what he was claiming was true or not, because he's known to be a congenital liar. Yet they went ahead and have another investigation done by another senior police officer, and that report was then subsequently turned over to the Prime Minister as well again, even after they were told that that was incorrect, that was not the proper process, procedure, or protocol, and that they were in violation of the Constitution and the very investigative process and the prosecutorial process. And they were advised that that matter should have gone to the Director of Public Prosecution. But the Prime Minister wanted to know what was in that report, because that report could have came very close to the Prime Minister himself. So he needed to be able to see how close it was getting to him in order for him to do whatever he needs to do, which, as we turned out or found out later on, when they did follow the proper procedures after the fact and sent the matter to the DPP office, the DPP could have said in public that what was in the file was less than nothing. How the hell can that happen? After a second report was being, the second investigation was done and being produced, the DPP had the audacity and the temerity, the gall, the fortitude to say that what was given to her was less than nothing. In other words, there was nothing there that she could use to prosecute anyone in regards to that particular matter. And what did the Prime Minister reply with? It is the DPP's prerogative, because that's how the system is set up. Confessing, in other words, to the fact that he put his finger on the scale when he should not have done so and should not have acted in such an onerous way, because in the first place, it was none of his business to be able to get involved in that type of activity, and to suborn the powers of his office for personal agendas. And they don't like to be called out and be told that they're acting like scofflaws, or they're acting like goons, or they're acting, out of order. I could care less what they like or don't like. Do the right thing. as far as I'm concerned. Then you won't have to hear that I have anything to say because you're doing the right thing. If you're not doing the right thing, I have the right, the authority vested in me as a citizen to speak to these matters. And if you don't like so, tough luck. That's my constitutional right. That's my God given prerogative. That's my natural right. And I'm speaking within the boundaries of lawfulness, legality, and constitutional prescripts. I have 25 more minutes to go. I'll just skip this particular section here and make a commentary on another part of this presentation. In regards to, it says, uh, in regards to this, let me read this little part here before I make my comment on it, okay, please? Mr. Avellard alleged a broader pattern of police harassment and extortion dating back to 2021. In other words, from 2021 to 2024, he was going through a process of harassment and um, basically, that's the period of time when the unspecified sums of $800 and $650 and $1,500 were also taken away from him under different schemes or scams. But because he could not or did not name the officers in his pleading, that part was struck out. And the fact that he was claiming to have been injured during the arrest process and was demanding $193,250 for general damages and emotional uh, distress and compensation. It then seemed like because he was suing the government, that the judge then would say, okay, well, you're suing the government, you're not suing a private person. If it was a private person, maybe the judge would have allowed that suit to go, or that portion of the evidence that the gentleman was trying to submit. He, the judge may have accepted it as evidence, and probably that would have become part of the bigger or the overall case, rather than just cutting down the man's case a little bit at a time to the point where it becomes almost a nullity. Why? Because the judge has to be paid by the government, so the judge now will entertain no case against the government having to pay out no big amount of money like that. So the judge is protecting the government. The judge wasn't there when the government was committing the crime, or the people who committed the crime was doing so on behalf of the government. But now the judge don't see any reason why the government should have to pay for the damages done by its subordinate officers. And the man cannot sue the subordinate officers directly because they are in the employment of the government. So the system stinks from the get-go. The way it is set up for them to exculpate criminal conduct on the part of some of their own subordinates. And this gentleman could not sue those individuals because they were claiming that they were doing their jobs as members of or officers of the government. So therefore the government have to go and bat for them. So the gentleman, for all intents and purposes, have no recourse or redress for the crimes committed against him. And the judge is precluding him from being able to submit any of those evidence as part of his claims. Bunch of jackals and hyenas. I'll skip the other portion and go down a little further make another comment on. So the justice split the claims into two categories. The first covered the detention process. And because the detention was done and the crimes were committed during the time of the detention, and a few other crimes were committed afterwards, because the gentleman filed late, the judge is going to use technicalities again under Section 27 of the Belize Limitation uh, Act, claims against the public officers, as a way to dispense with the gentleman's case, or that part of his case. That is that the fact that the crime was committed against him is exculpated by virtue, not because the crime didn't get committed, but the crime is exculpated by virtue of time limitations that precluded the gentleman filing after a drop dead date. He didn't meet that requirement, he didn't file on time, so therefore, the fact that the crime was committed is a nullity or a nullification factor by means of the late filing. Not everybody is a lawyer. Not everybody knows what documents need to be filed and on what timely basis they need to be filed and how often they need to be filed. And if you're a poor person and can't afford a lawyer, that means then that your rights are to be forfeited because of your poverty. The court, the higher court, appellate court, spoke to that matter in a different case, which became settled law or stare decisis. That is that on any other case that is similar to that particular one, the judges are supposed to rule according to the established and settled case law. But this jackal judge in this particular case is not abiding by those settled law. He's pulling this gentleman's ability to be able to try and get the court to vindicate his rights, which are enshrined in the Constitution, and they are just going to glaze over the fact that the crime may have been committed have no bearings on the fact that because you file late, you're not allowed to gain vindication for the crimes committed against you. That's honorousness. That's technicality. That's hiding behind technicality and not resolving the original base or substance of the case or the reason for filing the case. That's like a slap in the man's face. The government stormtroopers, they beat up the man, stamp on his chest, then do all kind of craziness to him. And when he goes to the court now to have this matter dealt with, he's precluded from being able to go forward with it because he didn't brought it according to their timing, and according to their schedules, their process, procedures, and protocol, which they as lawyers may know, but the average civilians may not know. And even if the average civilian may know and he can't come up with the money, he still can't buy justice, in other words. Justice is not to be bought by only those who have the resources to afford justice. Justice is to be given to just about any other person in a society. In other words, it's not just only the rich who can afford a lawyer should get justice. The system must seem to be fair, even when they're not being fair. At the least, they're supposed to provide somebody that doesn't have the ability to get a lawyer. They're supposed to provide them with some legal counseling or a lawyer, especially if you're going to go up against the government. This is the The government are us, all of us together are the government. The government caretakers are not above the laws. So they should not be able to beat you down in the ground and then turn around and put a barrier between you and your ability to be able to gain justice for the crimes that they commit against you. They're just our caretaker, and they're caretaking responsibility as they swear their allegiance to the constitution of the country and the people of the country and the country to not do harm to anybody, especially doing so gratuitously. And then with our own money that we the people sponsor the system with. I'm sorry. Okay. I'm within 13 minutes of the end of my presentation. So knowing that, I'll just skip this part that I was commenting on and go a little further down and make another commentary on it. If you notice, I've been making my commentary in a disjointed manner, right? And that is because I had offered in the beginning of the presentation to not make the comments in the middle of the reading, which is my preferred way of doing it. But I thought I'll do it differently this time, and hopefully it will have served a better or more a purpose of clarity. But I'm going to go ahead and do the best I can within the time limitation that I have right now. Again, this gentleman got into problems because of time limitation, and I don't want to get into problems because of time limitation either, which I'm getting close to the ending. So let me try and use the next 12 minutes effectively. The second category was the extortion allegations. And because he did not provide any names, he only provided the amounts and the date. The judge decided to throw that part of his case out as well. What is called case management in the judiciary and legal system is not actually the hearing of the case proper. Okay? For those who don't understand the legal system or the process. I just made that comment because the case management process is to facilitate bringing together the documentations that would be provided as evidence when the case is fully heard. To me, I believe it's a travesty that during some of these case management, people's case are minimized or cut down, or bits and pieces of their evidence is thrown out, so that then they end up with a disjointed case that unto itself sometimes doesn't seem correct, or bits and pieces are missing out. And the bits and pieces that are missing out are the very same pieces that they throw out initially through the case management process. So how the devils are you going to throw out part of the people in a case through case management, and then later on when the full case is being heard, those bits and pieces of evidence is not available to clarify and produce the substance that is necessary for the person who filed the case, especially being able to gain victory at the through the legal process when their evidence is already truncated. You call that throwing a case. And some lawyers are very good at that. And some judges apparently are very accommodating of that. That is that if you go into court unrepresented or without a lawyer and you try to just say to the judge what you know the facts to be, the judge is going to defer to the lawyers who are members of their society, legal society, and give them uh, leeway or preference in terms of how the court system works if you don't know how it works. So while the judge is going to make certain ruling to facilitate your case being suppressed, the lawyer is not going to be treated like that, and the judge is going to let that lawyer present evidence and information into the record that you will not have in your record. And even though you might want to have an appeal later on, you will not have access to those information because it is only what the judge accepts as a part of the record and evidence that an appellate court is going to have accessible to them to look at to determine whether or not you was given justice previously. And why is it then that you're asking the appellate court to look at the misjudgment or the wrong judgment, or how come that you didn't get judgment and that you still feel aggrieved, and hope that the appellate court will look at the evidence and see that a travesty or an error or an omission or a deliberate malfeasance occurred? You won't have that advantage, that privilege, which is why some of these jackals they play fast and loose, and they don't accept certain things into evidence, and therefore your case becomes, faulty, or it become weaker. Um, for example, I'm going to make a statement here under the judge was saying that that the payments that the gentleman was claiming or making claim about were impermissible, vague, and based on Civil Procedures Rule number 8.7, Section 1, they should not be entertained or allowed to go forward. Now then, come up with all these technicalities that are in the law. And remember now, when I say the law, in this particular instance that we're talking about, because I talk a lot about law on legal matters, on constitutional matters on Fridays, right? But when you talk about law, there are different types of laws. Okay, you have the constitution of a country. In the case of our country, Belize, you have the Constitution of Belize, which is the supreme law of the land. And if any other law, you hear what I said just now? Other law. In other words, laws that are other than the supreme law itself, or laws that are other than the Constitution itself, which tells you that the Constitution is one group of laws, and then you have other law. So if any of those other law is inconsistent with the Constitution, those other law, to the extent of their inconsistencies, are null and void. And the other law are, for example, laws, substantive laws, for example, in the hierarchy of the different laws, right? You have the substantive laws that the legislature body vote into existence or bring into existence through their own procedures and protocols. Now, none of those laws, unless they meet certain requirements, cannot trump the Constitution itself or specific portions of the Constitution, such as, for example, any law that is made by the House of Representatives that violates the Constitution or is violative of the Constitution is null and void. So it's telling you that from the get-go, from the beginning, any such law is stillbirth. It has not the effect and the legality or lawfulness attached to it, or the power of law attached to it, that allows it to be a valid law. Which is why you find in many cases that the courts would invalidate a law or a law that was presumed to be legal, lawful, and constitutional, because it was supposed to be made by the legislator, but that the legislator unto themselves had overreached and had created a law that was violative of the Constitution, inconsistent with the Constitution, and therefore void. And then you have other laws that are not the Constitution or that are not the substantive laws that are made by the House. You have what you call rules and regulations or procedures that are made by different government departments to manage how they conduct their affairs within those departments. Those laws require ministerial authority vested in them, such as a statutory instrument, to allow them to have any effect of law. But none of those laws can trump the Constitution because, like I said, statutory instruments, procedures, protocols, or departmental regulations cannot trump the Constitution, because the Constitution says under Section 2, the Constitution is the supreme law of the land. And everything else that falls out of that has to comply within and or come under the Constitution. Any law that is made, any procedures that is made, cannot be violative of the Constitution or the constitutional rights of people. Why? Because a statutory instrument, a procedure, a protocol, none of those things can trump the Constitution. They're all subordinate laws to the Constitution, in other words. I think I'm down to a small amount of minutes left. 27. Oh, yeah. I'm down to like 2.5 to 3 minutes left. So, knowing that I'm that close to the end of my program for tonight, I still had at least another. No, I won't be able to do that in 2 to 3 minutes. So I'll have to forego. I'll deal with one other little part and then I close it off. It says, however, the allegation naming 2 specific officers and specific dates and amount of okay. However, the allegation naming 2 specific officers and a specific date and amount had actually survived both challenges. That is, that the judge in his case management process had decided to knock out of the evidentiary document the fact that the gentleman wanted to present all those extra documents. The judge had precluded him from being able to submit those in the final hearing. And as a result, he agreed that some things here had survived his 2 measuring rod that he used to control what will be accepted and what will not be accepted. And what he decided would go forward was only the judge found it sufficiently pleaded and reasoned that execution, unlike lawful sorry, not execution, extortion. Let me read that over again for clarity. The judge found it sufficiently pleaded and reasoned that extortion, unlike lawful policing action, is not an act done in the execution of any statute or public duty, and therefore falls outside the limitations. So, in other words, as regards to the claim that the gentleman was making about extortion, the judge is going to allow that to stay. So he can plead or he can sue for the extortion that was done to him But the judge is not going to allow all the other things that was done to him before they get to the point of even the uh, the extortion. In other words, how is he going to prove, like I said earlier, how is he going to prove that they extorted him, and under what circumstance would they have had an ability to be able to extort him if the previous part of the case is thrown out and it's not available as part of the evidence that he wants to submit? His lawyer will not be able to speak to those if the judge decides to throw out the rest of the man case, and the man go to a appellate court level, which most people wouldn't have the facility or the money to be able to afford that anyhow. But let's say for all intents and purposes that were to happen. Even at that point, the appellate court would only see what the judge initially accepted, and if the judge refused to accept certain information, then the appellate court could only look on what was accepted, and what was accepted wouldn't make no sense because there's no basis for him to be able to say, well, these people extorted me. The appellate court would want to know, well, how come they get to the point of being able to extort you when you don't have another crime, a primary crime? The extortion is a secondary crime. I hope people understand what I was talking about tonight because it's very critical and important. You have what you call primary charges that are being thrown out by the judge so that they're not available then for the gentleman to refer to and to contextualize the crime that was committed against him and the various bits and pieces of it unto themselves would not stand proper scrutiny. And when an appellate court is reading through and among themselves, the appellate judges then are discussing these matters, if there's no context, it weakens what you call credibility or their credibility. They can't award a change of decision on behalf of a plaintiff if the plaintiff submissions or the plaintiff evidence is not full or complete or have enough substance. And these are how a lot of people lose their case. It's not because they're not correct or they're not right in pursuit of justice. They're being taken advantage by the system. On that point, I think I would like to yield and close off our program for tonight. I hope in what I presented, of course, the article wasn't written by myself. I'm just commenting on the article. I'm trying to show relevance of how the legal system operates and how it allows for some people to be disenfranchised or being dismissed and not being able to earn or gain proper vindication, even though their rights are being violated. And if they don't have a lawyer or a good enough lawyer who is knowledgeable about these matters and can point the judge in a direction where the judge has to yield according to the law, then you may not get justice. So I hope, having listened to this presentation tonight, it may have served, or it would serve, um, at least as a matter of basic information to some people. Um, I would just like to say thank you very much for your time, Spirit, to listen to what we have to offer tonight. I hope that um, those of you who listened to our program tonight while it was live, and or those who will be listening afterwards, or maybe over the weekend or at some future date, that somehow or another you'll derive some positive public benefit and a little further elucidation on some of these matters. Thank you very much again, and good night. Hopefully, we might get to see you on Monday when we have a different presenter. Goodbye.